Hello, everyone, and welcome to today's program, Examples in Elder Law, How You Can Add Value to Your Estate Planning Cases, sponsored by ElderCounsel and the Elder Law section of the New York State Bar Association. Today's program will run from 11 a.m. to 11:30 a.m. During the live webinar, participants are welcome to post questions using the Q&A tab in the Zoom portal. A PDF of the course materials are available in your dashboard, and instructions on how to access your learning dashboard are also available in the greetings email you received earlier today. At this time, I'd like to hand it over to our first speaker for today, Jim Wolverton.
Thanks so much, Tara. My name is Jim Wolverton. As Tara mentioned, I work as the Director of Education for ElderCounsel. And at ElderCounsel, we provide education, document assembly services, and marketing support to estate planning and elder law attorneys across the country. What I'm going to cover today is examples in elder law and specifically how you can add value to your estate planning cases. So what we'll do is we'll take where that moment where estate planning and elder law intersect, and we'll talk about what type of value you could bring to the table from just a basic estate planning case and expand it out into an elder law case, and how an elder law attorney would look at a particular case and kind of take that to the next level, for lack of a better term, in being able to handle the planning for the lifetime of their clients. And I have been joined by an esteemed colleague of mine, Howie Crooks. He is an attorney that focuses his practice on estate planning and elder law and is licensed in New York and Florida. So Howie, thank you so much for being here to add a little bit more context to the presentation here today.
Good morning. How are you, Jim?
I'm doing great. And thank you guys so much for being you, those attendees that are attending. Howie, just to give a little bit of context to what I'm talking about here, could you explain a little bit of how your elder law career would have been different had you just limited yourself to just that estate planning, those estate plans?
Yeah, so I think that the elder law practice itself is a much more holistic practice. It involves legal issues that you typically wouldn't see in a pure estate planning context. You really get into some psychosocial issues when you get into elder law planning. There are a lot of emotions that are wrapped up in this type of planning, and the problem solving that you do is very real. It's not transactional. And so, but it's one of the things that initially attracted me very much to the elder law practice is helping real people solve real problems, and you really felt like you made a difference in their lives, and it's really true. You are, and I'm not to say that you're not doing similar things in the estate planning world, but it's perhaps a little bit less personal and less of a connection to the client in my experience.
Oh, that's so great. Thank you so much, Howie, for that. So what we'll do first is we'll kind of give a really high-level overview of three specific planning areas that work really well with estate planning. And the first one we're going to talk about is proactive Medicaid planning. The second is veterans pension planning, and the third is special needs planning. And with Medicaid, proactive Medicaid planning, for those of you that aren't familiar with what that means, is Medicaid is a federal and state program that helps pay for the cost of long-term care. And that's usually folks that are in a nursing home already or having to go into a nursing home. And what that requires is specific financial and medical needs in order to begin that Medicaid assistance kicking in and help paying for that. And proactive planning, what we're trying to do there is avoid what's called a penalty period. So we would do our asset transfers further out than 5 years before submitting an application for Medicaid, because transfers made within that 5-year window that's called the look back period are penalized. And assets transferred in a properly drafted irrevocable trust, which were transferred more than 5 years prior to the application, are not only not counted for qualification purposes, but are also protected from Medicaid making a claim against those once the person who received benefits passes away from their estate. And that's called estate recovery. And that's a really, really important reason to use some of these strategies that elder law attorneys use. Howie, are there other Medicaid benefits specific to New York State that you talk to your clients about when you're having that initial consult?
Sure. There are essentially three levels of care that we talk to our clients about. One is most people will come to you and say, I want to stay at home. 99% of people would rather stay at home. Of course, not everybody can because of medical issues, but home care is a program that's available in New York. And New York happens to have one of the more robust home care programs nationally. So you're going to want to talk to your clients about availability and access to home care, although over the years, some of the access has diminished and some of the eligibility requirements have become more stringent. It still happens to be a very good program. And then there's also an assisted living program, which is a little bit more difficult to qualify for and a little bit more sparse in terms of the assisted living beds that are available. But nevertheless, you may have clients that are seeking assisted living program benefits. And then finally, the highest level of care being the skilled nursing facility care that unfortunately some people need to qualify for.
Excellent. Thank you so much, Howie, for that insight. So let's do a fact pattern. And I always find examples really helpful to put kind of some bones around or some meat around some of these bones that we've been talking about. So we'll do the first one. This is George. He's coming in to see you for a revocable living trust. George is 70 years old, still plays tennis 3 times a week, and has a girlfriend he's been seeing for the last 2 years. George is a widower. He has a home worth $475,000 that's free and clear with no mortgage on it, and total liquid assets of $325,000. He wants to revise his current trust to provide a small cash amount to his girlfriend and leave the rest in trust to his children. George has income of $3,500, and that covers most of his monthly expenses. So George has done a really good job of planning for his life and has a nice cash flow coming out. So traditionally, and before I learned about elder law, what I probably would have done is taken George's word for what he wanted and update that revocable living trust to make sure that we had the distribution set up for when he passes away, that everything's going exactly the way that he wanted it to. And then also I would review his financial power of attorney, his healthcare proxy, and his living will, and make sure those are in order with the proper agents and documentation. As time passes, obviously those need to be updated on a regular basis. However, an elder law attorney, such as Howie, might expand that conversation and bring to light some things that George might not know about. And this is what we covered on our previous 2 webinars that we did with the New York State Bar. So if you want to take a deep dive into some of these numbers and how important this type of planning is, we did cover that. But what you really want to hammer home with George is, hey, there's 70% of the folks in our country need some sort of long-term care before they pass away. And the cost of that is ridiculous, unfortunately. And New York is one of the more expensive states in the country, coming in at about $13,000 per month for a private room. So if we don't help George help pay for that, he could be jeopardizing all of those resources that he spent his whole life saving up just to pay for the cost of long-term care. Should he perhaps have a stroke, break a hip while he's playing tennis, is no longer safe at home anymore. Now his goals of transferring those assets to his girlfriend and his kids when he passes away, where he's going to transfer those assets to is the skilled nursing facility that he may end up staying at. So what we're going to do is we're going to work with George to figure out what would make the most sense as far as funding maybe some assets into a revocable living trust, balancing that with an irrevocable trust, and then seeing if there's any long-term care insurance policies that are available out there that make sense for him, so he could privately pay for that care should he need it and not have to spend down any of the money that he's saved up, and he would much rather have go to his kids rather than into a nursing home. And Howie, I think one of the bigger challenges that attorneys have when the client comes in with a plan, a real basic estate plan update, is expanding that conversation with potential clients into some of these concerns that you have for them that they're actually going to achieve their goals. Do you have any tips and pointers to help the folks on the call today to how do you have kind of take a basic estate plan conversation into an elder law long-term care type planning solution?
Yeah, I think there are a couple of entrees into that, Jim. Number one, you could just ask whether or not the client has a long-term care insurance policy in place. And depending upon their response, that's really your portal into the discussion. Because if they don't have it, you might ask them if they've ever thought about it. They may even say no. You get these difficult clients that don't give you a ready access to the discussion. But having said that, once you bring up the idea of long-term care insurance, you kind of have your own ready-made doorway into the discussion, because you probably have sent a questionnaire, you know what their assets are, you're talking about revocable trust, you know, you're talking about estate planning. So you could ask them the question, well, you know, I happen to know that the cost of a room in a skilled nursing facility is, you know, 13,000 is light in some, you know, parts of New York State. It could be higher, it could be 14, 15, 16, $17,000 a month. If that were to happen, you know, how would you go about paying for the care? Now, depending upon the size of the estate, some people may actually be able to self-finance, and maybe it's not a concern. Although I find that many people with multi-million-dollar estates want to have long-term care insurance because they want their estate to fully go to their heirs. But if it's a lesser size estate, then it's even more critical, because you could demonstrate for them very quickly through some simple math. Look, you know, if you ended up here, even though you don't want to, your estate's going to be completely depleted within, say, 2 to 3 years. Is that what you really want to happen? And so we have to talk about underwriting for long-term care insurance or Medicaid planning, but that would be a good entree into, if you're not somebody who could be underwritten for a long-term care insurance, maybe we should be talking about an irrevocable trust. But there's lots of different ways that you can sort of broach the subject. And when you ask them the question, how do you propose to pay for that care? Usually you get the deer in the headlight look. And that's when it's time to suggest to them that, look, I can help you through this process. Maybe we need to bring your financial advisor into the discussion and help figure out what would happen also at the various levels of care, right? You might need home care aid, and you might not need nursing home. And so it's a very complex discussion, but if it's one that they have not thought about, I would submit to you, it is your job as the elder law attorney to plant these seeds and give them something to think about.
And I know, Howie, you mentioned long-term care insurance policies. I know that's been kind of a revolving area with that insurance product. Can you talk about what you're seeing out there now when you're talking to clients that are purchasing those now? Kind of, is there more flexibility in it, or is it still the all use it and lose it type insurance policy?
Yeah, so it's much better than it was. The use it and lose it, more traditional policies have largely gone by the wayside. The insurance industry was not very successful in achieving much more than a 10 or 11% market penetration with those policies. They're fraught with issues down the road where, although they're supposedly fixed in terms of premiums, if the insurance company goes to the State Department of Insurance and gets a class-wide premium increase, then all of a sudden your client can get a letter saying, hey, guess what? Either you reduce the scope of coverage or we're raising your premium. So they really are fraught with problems, and that's why they're not very successful. Having said that, over the last 5 to 7 years, we've morphed into a new product, which is a life insurance policy that has a long-term care rider attached to it, where if you don't use it, you don't lose it, your heirs will benefit to the extent of the life insurance coverage that you purchased. And then if you do use it, you're essentially just reducing the amount of the life insurance payout at your death, but at least it's not a total loss. And so people tend to feel much more comfortable psychologically going into that purchase, knowing that if I'm paying all this money in premiums and I think I might not ever use it, which in itself is probably a misplaced assumption, but if I never use it, why am I paying all this money? At least I feel like I'm buying something, which is the security of my heirs through a payout at my death on the life insurance part of the policy.
Yeah, that sounds like such a much better product and a much better option for the consumer to be able to make sure that they're still getting some value out of all those premiums they paid into that insurance product. Thanks, Howie. So what we could do for George is, and these are, again, just very high level examples, do not take this to the bank, update the financial power of attorney with enhanced powers, create a healthcare proxy and living will documents, make sure all of those are in compliance with what George needs now. Maybe we move $200,000 of liquid assets into a revocable trust so that he has enough money to do whatever he wants to. Again, we're not impacting his quality of life. And then we can use the rest of the liquid assets, move those into an irrevocable trust, and then move the home over there as well. So we know that that is locked up, that is protected. We can guarantee that that's going to go to his kids, a little bit to his girlfriend, and the rest will go, you know, exactly the way that he wants it to go. And then we find one of these long-term care insurance policy or the life insurance policy with a long-term care rider, so he can privately pay for the nursing home if needed if needed, and we can fund that with that revocable living trust to pay those premiums. And what this does is we have created no impact to his current income. So he's still getting that $3,500 that he's living off of, but now he has coverage for his care should he need it down the road. And as Howie mentioned, he still has a life insurance policy that's going to pay out to his kids. So if he doesn't even use it, but should he need to use it, he has a private way to pay for that care. And now we've given him all the flexibility in the world that he needs, and he can make the decision. Maybe that long-term care insurance policy runs out, then he could apply for Medicaid if he needed to. But if we're doing a good job in proactive planning, our clients may not ever need to make that Medicaid application. So what we've done is we've met his planning goals. We've made sure that his girlfriend and his kids are getting some of that money that he's saved up in the value of his home. We have no impact to his current income and coverage for his care should he need it down the road. That's all planned out to be implemented. This is not going to be a crisis problem. It's not going to come as a surprise. That cost of long-term care, like Howie mentioned, in some parts of New York, could go all the way up to $17,000. That's not going to blow him off his seat. We have a plan in place to pay for that. And his home and some of those liquid assets are protected from estate recovery should he decide to apply for Medicaid assistance in the future. So hopefully that'll show you, with adding proactive Medicaid planning to a really simple client case that came in just to update a revocable living trust, and that amount of value you can bring to the table will allow you to talk to your clients maybe in a different way and help them prepare for something that they might not have walked in the door ready to talk about. Howie, anything else you want to add to the proactive Medicaid example that we have there?
No, I think you did good there.
Okay, cool. We're going to talk about the second benefit that we have to cover, and that's called VA pension. And this is a specific benefit that's available to wartime veterans or their surviving spouses that need help with activities of daily living, and they can receive a monthly payment to help pay for their care. And this can be up to $2,431 per month. This does, again, require the specific financial and medical needs, but they're way less restrictive than Medicaid. And that's really the beautiful part about this benefit that the wartime benefit or the wartime veterans have earned. You can transfer certain assets within 3 years, but those will be penalized. However, assets held in a properly drafted irrevocable trust are not counted for qualification purposes. But again, transfers within that 3-year look back for this VA pension benefit are penalized. But this benefit is really great because it's a monthly income-free cash payment to the veteran or their surviving spouse, and they're allowed to keep up to $138,000 of assets plus the home and still qualify for this benefit. And one of the keys to this benefit is you don't necessarily have to be at that really high level of skilled nursing home. It's very akin to some of those other Medicaid benefits that New York offers, but it's available specifically to wartime veterans so they can stay in their home and receive that care from a caregiver. So let's drill into this. Let's do a quick fact pattern on this one. We have Vern comes into your office. He served during the Korean War. He was recently diagnosed with Parkinson's, and he and his family are concerned that they're going to need some help with his care as he gets older. This is one of those diseases that as you get older, it progresses and makes things a little bit harder to care for Vern. So right now, Vern has a home with liquid savings of $230,000. He'd like to leave his money in his home to his 2 kids when he passes away. So a traditional estate planning solution here would be to create a will or revocable trust to avoid having to file probate in surrogate's court that is concurrent with his wishes and leave his home and money to his kids. Again, we're going to update financial power of attorney, healthcare proxy, living will to comply with his wishes. And then we'll use his money, or we might have to sell the house to pay for his care should it get beyond the kids' ability to be his caregivers. And this is what happens a lot with these degenerative types of diseases, is the kids will start out saying, we got this, we can take care of Vern, no problem. But as things get, more dangerous for him to be at home alone, and this happened to my grandmother, my uncle was taking care of her. He has to go to work. He has to leave her at home alone. So he's going to start down this path of paying for a caregiver very slowly. He had someone come into the house. Then he started using adult daycare. Then she went to independent living. Then she went to assisted living, and eventually in a nursing home, and then memory care. So she went through that whole spectrum of care. And each step along that spectrum gets more and more expensive. So with this particular solution, what we can do is use a revocable trust to provide for Vern's daily expenses. And then we move $50,000 and the home over into an irrevocable trust, and we create financial powers of attorney again, should planning be needed and Vern is incapacitated. And what we could do is we could qualify Vern for a VA pension for this and a monthly payment in 22 months. And this money will help him stay in the least restrictive environment for as long as possible. So what you're doing here is you're allowing Vern to meet his goals, and then you're setting him up to receive this monthly cash payment through the VA to help with in-home care should he need someone to come into the house, take care of Vern, and you're also protecting those liquid assets in his home. And one thing, and I just went to a webinar yesterday about this, is one of the main reasons you want to use an irrevocable trust for a home is there are all sorts of advanced financial scams right now to try to get people to give away the equity in their homes that they've earned over their lifetime. And using an irrevocable trust puts a trustee in charge of that home, and somebody that might have reduced capacity is no longer a target for some of these scam artists to come in and take away what Vern has worked his whole life to, is that to build that equity in his home. And what I really like about this benefit, again, is it's a monthly cash payment that Vern can use to have caregivers come into his home and take care of him in a place where he's comfortable and he's safe. And he doesn't necessarily have to move out of the house because he couldn't afford to bring in some caregivers. Howie, how do you use this VA pension planning to help wartime vets and their spouse stay in their home and receive care?
Yeah, so I think most critically is depending upon what state you're practicing, and I know this is New York, where we have a robust home care program, but other states do not. And as you mentioned earlier, Jim, I practice in Florida. So in Florida, there's a wait list for services. And that's a problem because you need the services now, you really can't afford to wait. New York doesn't have such a wait list, although there may be some initial time in filing and processing the application. But once you're approved, your services are going to be put in place. So I've used it when anytime there's a state that doesn't have as robust a program or a wait list, you can put these VA services in place, because once you're approved for the VA, you get the check every month, and now you can use that money to pay for the aids. And that can be very, very helpful where the Medicaid program is not as robust. But even in a state like New York, where it is, when you apply for home care services, you don't just say, I need 24/7 care, and then you get it. You apply for what you need, but you and Medicaid may disagree on the number of hours of care that you might be authorized to receive. So it's nice if you are a veteran and you have access to the VA benefit, and then this cash payment can supplement that which Medicaid does not cover. So if you only get 4, 6, 8 hours a day, getting this check every month will allow you to use that money and supplement the portion of care that you need, but which Medicaid has declined to pay.
Oh, that's great. Yeah, and again, this is available to wartime veterans that served our country. They earn this pension benefit, and I'll tell you, not even all the elder law attorneys that we work with use this benefit or even know about this benefit. So hopefully that rang true for you guys here on the webinar today. The last benefit that we'll talk about, or the last type of planning that we'll talk about that really intersects well with estate planning, is special needs trust planning. And persons with disabilities who are unable to work can receive what's called Social Security income benefits. And another really nice kicker with this is they automatically qualify for what's called community medical assistance or community Medicaid, which can really be essential to their quality of life. And it comes with things like transportation, group therapy, things like that they would have to pay out of pocket for. To receive SSI, you do have to, again, meet those income and resource limits. But what you can use are two types of trust. You can use a first-party special needs trust, which allow for people with disabilities to maintain resources above their limits and use those resources to supplement their care. Then there's also third-party special needs trust, and this is what really comes into estate planning, which allows for family members to give a disabled person money without impacting their benefits. So if you were just to give those, make that inheritance outright, they may lose that community Medicaid. They may lose that SSI check that they're using to take care of themselves with. So let's just do a fact pattern. And this was one that came across my desk when I was in practice. We have Mary, who's a longtime business client who has a child with autism who's turning 18 in the next few months. Her name is Erin. Her parents are aging, and they're concerned that if they leave Erin without any sort of benefits, then how do we know we make sure that she's still attending her group activities, she's getting the therapy that she needs? And she uses community Medicaid funded transportation to attend those activities and her therapy. So I have up here the estate planning solution, or what some attorneys do. This is what I unfortunately did, is we just created powers of attorney for Erin, and we named Mary as the agent. We created a revocable trust for Mary where the parents were leaving the inheritance directly to her, or they were leaving, it was actually Mary's parents were leaving money for Erin in Mary's name so they could take care of Erin. And what we probably should have done is referred her out to somebody that did this type of planning, but she was a favorite client of ours. So we really had this desire to help this client, but I was way in over my head and I didn't know the solutions that were out there. A more comprehensive solution, and this is where special needs planning and what Howie was talking about is really getting into the client's lives and really becoming that counselor, is better understand what is Erin, what can Erin do? What are we comfortable? What's her capacity to manage her own affairs? And how are her grandparents' assets being held? And based on her ability to manage her own money, let's look up to setting what's called an ABLE account, where she can have an account that she can spend her own money on for whatever she needs. And it's a really, really wonderful tool that's come online in the last few years. You can also create a first party special needs trust, should she have her own funds to contribute if she's working, or a third party supplemental needs trust, so her grandparents can name that trust as beneficiary in any of their estate planning. And one thing that's happened since the Secure Act was passed is you can use what's called a secure special needs trust, and you can really take advantage of some of the rules in the tax code to allow Erin to have that account pay out for the remainder of her lifetime and get the stretch with income tax deferred that is only available to certain parties. People like Erin can take advantage of that and make sure that she's getting the benefit of that retirement account. So what we've done here is we've talked to the client, one of our favorites, we've met their planning goals. We've set up Erin for future financial support while ensuring that her benefits continue. And we've also, and this is, I think, the key point, is we've created a plan specifically to design for Erin and her abilities, so she doesn't feel like she's lost control of anything and someone has to take care of her. And we ensured this valued client and her family trust you as their attorney for multiple generations. So you've landed that relationship in a way that's set up so that not only Erin is successful, but you can help the family kind of navigate that. Howie, what do you see as the greatest value of these disability benefits for families that have loved ones that have special needs?
Yeah, I think that if you are not familiar with this area of the law and planning, it may not be apparent to you that if you have a child with special needs or a family member with special needs, just the amount of resources that you need to adequately care for another individual, the needs are tremendous. And I'm not just talking about financial here. I'm talking about human resources needs, medical care, social programs, psychosocial needs. It is a tremendous responsibility for the family to meet all of those needs. And to be quite frank about it, government benefit programs, they barely scratch the surface of the needs of a special needs individual. And so what I really, really like about the ability to plan utilizing the supplemental needs trusts is that it allows a person to live their best life, so to speak, and a quality of life that at least is attainable for them. And it brings dignity to their lives. Right. And so critically important to be able to do that. And the planning that we do with our special needs clients, so it allows us to help them achieve their goals in that way.
Yeah, that's so well said, Howie. And I can tell you that the attorneys that work in special needs are some of the kindest and most rewarded attorneys that work out there in this planning space, because they are helping these families in an area that not a lot of attorneys really understand. In conclusion, just to wrap this up, elder law is helping clients and their families through every stage of the aging process regarding health or disability. It can also help maximize the client's desires to leave a legacy when they pass away by saving those resources and leveraging benefits that are available to them. And allows you to continue helping clients and loved ones throughout their lifetime. And that's why I like to call this elder law is lifetime planning rather than just estate planning, where we're thinking mostly what happens when your stuff after you pass away. Let's think about how we can maximize your quality of life before you pass away while making those estate planning goals a reality as well. If you'd like to learn more about ElderCounsel, you want to learn more about these practice areas and get some support in them, please feel free to use the link below to schedule a meeting with one of our membership advisors. And it looks like we're coming up next to the half hour. I didn't see any questions come through. So thank you everybody that attended here today. Special thanks to our VIP, Howie Crooks, for hopping on this webinar at the last minute for me. I really appreciate that. And Tara, thank you so much for your professionalism in putting the program together.
Thank you, Jim and Howard, for being here today presenting on this topic. This was great. So thank you again, and we hope to see you both in the future and do another program on this. And I also want to thank all the attendees for attending today, and this does conclude the seminar. So thank you all again, and I hope you have a great rest of your day.
Thanks so much.